All right, let's get started. So my name is Todd Sivia. I'm the owner of Sivia Law Firm. I've been practicing for about 15 years, or 16 years. Own my own practice for about 15 years. We currently have 9 attorneys on staff in four different locations. So we have an office in East Alton, Edwardsville, South County, and like kind of like the Clayton area. So we're kind of all spread out, and within those attorneys, we kind of all do different practice areas, and I'm more of a transactional attorney. Personal experience, I do have a special needs son. It was the result of a traumatic brain injury due to birth, associated with medical malpractice. So I'm very familiar with what we've got to plan for from a personal perspective. I know, thankfully, my son, he'd be similar to a high functioning autistic. So he's got deficiencies, but he's got higher capacity, but he still has deficiencies, and we still have the IEPs and all those wonderful programs that we got to go through as well. So I've definitely got a familiarity with that, and that's kind of one of the reasons for my passions to do planning associated with this, because I'm learning, anything that I'm doing, I'm applying and telling you exactly what I'm doing. So I'm in there researching, digging through, and understanding the laws, for my own purposes, which I can apply to my clients. So today we're going to talk about a few things. We're going to talk about planning for your future, yours and theirs, special needs trusts. We'll touch on some access to public benefits, power of attorneys, guardianships, wills and trusts, and maintaining and preserving lifestyle and the importance of the age of 18. And anytime when I talk about estate planning, I always talk about this, somebody told me this story a while back, and I thought it was very important. And if we've all been on, anybody not been on an airplane? Not recently, but but we've all, if you've been on an airplane, you hear the stewardess. And the stewardess comes through and talks about putting your seatbelt on and everything else like that. And then they talk about the air bags that come down. The most important thing that they say is put your mask on first before you help others. And if we take that in a little sense and apply it to ourselves, we as parents are always looking out for what we can do for our kids, but we don't take care of ourselves. And I think that's the one thing, if you leave here with anything, make sure you're taking care of yourself first and making sure you're financially taken care of. You focus in on, because your planning starts with yourself. Because if you don't have the resources for yourself to be able to take care of yourself, you can't help others. So we need to worry about your taking care of yourself, getting you in the right direction first, and then we start talking about how are we helping the kids. Because we need to make sure that you've got power of attorneys, you've got all your things set up, making sure that you're working, you've got enough life insurance for your spouse, or you've got enough resources for your spouse. Because, especially when we get up in age, and this is something that we have to think about, is what are we going to take care of our long-term care needs? Because those resources will be dropped significantly and won't provide any resources for the child. So we always have to be knowledgeable about the planning that we have to take big part. We also have to take care of ourselves first, which is totally opposite of being a parent. We're all focused on our kids, but it's an important aspect to understand. So, plan for the unexpected. If we look at everything we do, you know, I don't think anybody with a special needs kid would have expected, hey, this is what my plan was in my life. So I think we're a little bit more knowledgeable about there will be unexpected items, but you have to understand your current situation to evaluate where you're at. We need to understand that and figure out what our key priorities are, you know, for either for us or for the kids. You know, are we planning to, you know, do we need additional resources? Do we need to think about housing? Do we need to think about all the extras associated with things? Having transparency, especially in these circumstances, we need to be transparent not only between the internal nuclear family, we need to be transparent with the outside family. Make sure that everyone is on board with the plan. Because if you're not there to execute the plan, somebody else has to jump in and take over for you. And there's also lots of potential for pitfalls if we don't have that happen. I'm glad that we have your grandparent involved. Those are key functions because grandparents don't realize that they want to take care of their grandchild as well. And they may give money at the time of death to a child and accidentally disqualify them for benefits. So transparency with regards to what benefits are available and why planning is important and making sure that they know what they need to do to help your family is just as important. And then also balancing potential competing goals. So, you know, your competing goals with regards to you know, you want to take, you know, if you've got multiple kids, how are you balancing those goals? So, with regards to plan for the unexpected, you know, there's going to be all kinds of different situations that pop up. Marriage, divorce, birth, death, prolonged illnesses, for not just for you, but for also your child. So you got to plan for that. Government changes. You know, and I never want to talk about politics, but we're in the phase of getting ready for some tax law changes. You know, it's already been announced that there's going to be an increase in taxes. So that has to be a consideration in anything you do. There's a constant change of government benefits, and there's benefits that pop up, and there's benefits that go away. And it is a constant, ongoing thing. So you want to make sure that your plan is able to move with those issues that do arise. Again, if there's an incorrect implementation strategy, example would be somebody sold you a trust and then you didn't fund it, or you you think you're doing some kind of, you know, you say, okay, I just need a will, but then you've got, you know, lots of money to pass on to your child, and then you disqualify that child for benefits. So there's all kinds of different problems with that. So, you know, what is a special needs attorney? Now, the Illinois Supreme Court says that I can't specialize or offer any kind of specialized services. So I do not offer any kind of specialized services or anything of those lines. But there's a difference. There's a big difference between an attorney and somebody that does more transactional work. A personal injury attorney, your buddy down the street that may do personal injury work, is probably not going to know all the rules with regards to Medicaid, Medicare, and VA that are necessary to implement a plan. You know, there are so many laws out there, and it's hard to keep up with them. And if you don't practice in that area very often, you know, special needs attorneys, those that say that they do special needs, they're going to be a little bit more knowledgeable and see that area, those issues fairly often. You know, so they're going to be looking at, you know, special needs trusts and knowing the difference between a first-party trust, third-party trust, and things of that sort. Guardianships, public benefits, IEPs, and just general wills and trusts. So when we talk about estate planning, what is an estate plan? An estate plan is typically a combination, and I look at it as I've got, you know, I'm like a carpenter. I have this toolbox, and there are certain times when I use different tools within that toolbox. And that could be a power of attorney to do certain things. It could be a guardianship. It could be a trust. It could be a special needs trust. It could be doing beneficiaries or telling you how to, you know, how to do the beneficiaries in the correct way. You know, it could be as simple as that, and to solve your problems. So there's lots of different ways, and it doesn't, you know, it doesn't have to be. It can go from, you know, I always get, you know, what's the cost, right? But it's a wide-ranging issue depending upon your circumstances. So it could be as simple as, like I said, it could be as simple as a beneficiary change, and that solves all your problems. Or it could be a deed to your house. It could be some other things. So it just depends upon the circumstances. But it's really looking at evaluating your needs and your goals. And that's basically the best way to do that. So, which leads me to my Uncle Gene. I always talk about personal examples because I can, you know, I don't have to hide names to protect the innocent. I can use personal examples to explain the circumstances. And a lot of people don't realize the differences between wills and trusts. And my Uncle Gene went to an attorney. He had a will draft. And in that will, he did not have children. He had 26 nieces and nephews. And I was one of those nephews that was blessed by when he passed. And he had bank accounts and a house. It's really about it. It wasn't very complicated. The process was 2 years long. It was uncontested, so no one really fought over how to distribute the money. But it was stuck in court for 2 years. And the attorney made $5,000. The executor made $5,000 to cut 26 different checks and distribute it. So something as easy as that is called probate. And probate is a process of transferring all your assets from one generation to the next. And that is how wills go. Trusts are different. And in a trust scenario, trust is holding the assets outside of your you personally. So you don't own any of the assets. The trust owns the assets. And you've directed that you may be the trustee today, but it continues on. The life continues past your death and then distributes based upon your wishes after your death. So there is typically no court intervention unless somebody crazily fights it, which is something that has the possibility of doing that. But trusts continue on. And I used my grandpa Bob as the example of how that happened. My grandfather passed away. My mom was the only heir to my grandfather's estate. We had done a trust, put it in a trust. And with that trust, at the funeral, my mom said, okay, what's my next step? I said, Mom, go into the bank, take all those assets, put it into your name, and you're done. So compare the difference between Uncle Gene and my grandfather. It is amazingly simple.
Is that money or that real estate or?
It was money. He had a piece of real estate that needed to be sold.
All like the Washington Trust.
It was all in the trust. So if she wanted to keep the house, all she had to do was sign the deed to transfer it to herself, and she was done. So there's a lot of simplicity. People think, oh, I don't need a trust because I've been told I don't need a trust. But there are times when you do need trust. And not everybody needs a trust. But it does simplify a lot of things. So, when we're looking at your plan in itself, we have to look at, there are certain planning considerations. We can't, with a special needs, either adult or child, you can't be as simple as I described with my grandfather, because the complication is we're not handing the cash over to that person upon the person's death. It will continue on in some form or fashion. And that's where we start having to look at, from your plan, what is the considerations? What will that child need? So we're looking at, from transition from teen to adulthood, what's that child going to need? Can the child drive? Can the child, is there going to be a need for assistance in home? Is the child going to, will the child be able to transition to live on their own? And there's a lot of factors with regards to that. And we're looking at guardianship, and then public benefits, housing, post-secondary education. Are we looking at, like a life plan, college for life, either like SWIC or Lewis and Clark or any of those things. But then also just beyond academics, what are the continuous needs? So far, are we good? It's complicated. There's a lot of complications. We got to tell you there's a lot of complications. Do not hesitate to ask questions, because just know there's no such thing as a bad question. So please always ask questions. So let's talk about power of attorneys. Power of attorney this is important, and especially in the special needs arena, is we have to consider as an attorney, when somebody presents to me, and there's a question is, can that person sign a power of attorney? Do they have the capacity to sign that power of attorney? There are individuals there are children that transition to be adults that are capable of, truly capable of making financial decisions and being able to articulate and advocate for themselves. And if they can advocate for themselves, there's no need for a guardianship. And they can sign a power of attorney at age 18 that authorizes somebody to assist them and give the parents the ability to help them with their finances, help them with these things. But if they are not able to communicate or not able to articulate their wishes and desires, then we have to fall back to a guardianship. So that is key. If you, again, knowing the difference and knowing that is an available tool will save thousands of dollars. Because guardianships are expensive. Because not only are you, a lot of times, if it's clear, you don't need a guardian ad litem, but sometimes you'll need a guardian ad litem. So basically, you hire an attorney, and then the court hires another attorney to ensure that your attorney is doing what he's supposed to be doing to protect the interests of the minor. So you really, the minors, or the adult is able, that they agree with the order of the guardianship. So you're basically hiring two attorneys to agree that the child needs guardianship.
So we have to pay for the one at court once.
Yes. So, yes.
I actually have a question about that, because we have a guardian ad litem, and then we also have an attorney, and we're paying more in attorney's fees, and we're actually spending on our child. So is there a way to get rid of one of them at least, where you can be the guardian and not have to have the guardian ad litem? Because I'm spending like $10,000 on that one and $10,000 on the other.
We have.
Yeah. So.
That was quite a reaction.
So I'm trying to, like, right now, we're very conservative with our daughter's trust, like extremely conservative with our daughter's trust. And right now, for just us trying to get something accomplished takes like months. Just for them to talk back and forth to each other, both agree, and then get back to me and then go, oh, we sorry, we forgot to tell you you're good to go. And so is there a way to, because she's about to turn 17 in July, so I have to get this pretty quick because she's not mentally capable to do anything after the age of 18 on her own.
Okay.
So do I still have to keep the guardian ad litem? Or can I be that? Or can I just get like new lawyers all together?
You can always hire different lawyers.
Because
You can always have the option to hire different lawyers. The court, and I never want to say anything negative about attorneys. Because I really don't know the circumstances. But I would need to know more. I have a guess of what's going on, and there may be an easier solution to it.
Our daughter was born in 2004, and it was hospital malpractice. And so it was, she ended up having a grade 3 brain hemorrhage due to negligence of a nurse, and then has cerebral palsy and was impaired. And then so I was 19, 20 when I had my daughter, so I was very new. She was actually a twin, so she was tongue to twin, and they had tongue to twin syndrome, so they were both smaller than normal. Her sister passed away 2 weeks before she was born, so she already had a lot against her, but then the nurse did what she did, and then So I was just not in a state at the time to make sure I was doing right decisions when it came to lawyers. And my ex-husband at the time was the one who set it all up. So I really didn't have any say in it, but now I'm kind of stuck with it. So, and they're all state, and it's an irrevocable trust. So not a special needs trust. But they have a special needs trust set up unless, in case they need to dump their money into that.
So,
And this is all in North Carolina too, so does that matter where laws are?
yes, it does. So every attorney, especially in the different states. So our office primarily practices in Illinois, Missouri. I think pretty much everybody. I'm positive everybody is licensed in both Illinois and Missouri. We're not licensed in North Carolina. Okay, so some of the laws have some impact. There are some suggestions that you probably make to eliminate some of those issues, but probably not.
Here, yeah.
Right, so.
But is it doable? Like, is it like?
There's definitely some things you can
Do better. Okay. I'll set them up.
He's choosing his word very carefully.
He could talk all day.
Yeah, we can talk all day. So, everybody's circumstances are different, and that's a problem with giving presentations and things of that sort, is because everybody's situation is different. And for me to say, this is the right way, or this is the wrong way, or you have to look at it in the context of what's being presented. And that's the hard part of laws. You're taking what the situation is and trying to apply the laws to narrow it down and guide you in the right direction. But my child received a similar issue, and we've got an irrevocable trust, and I've got, I was able to draft it, and it is not in the state of Illinois, so I'm thankful for that, and not taxed here, so. But those are some of the things, there's some planning tools and things of that sort that we can talk through. But, all right, so going back, power of attorneys, guardianships. The key thing, and I think you guys probably know more than most parents, that as the age of 18, you lose all rights to make decisions about your child. So that is probably the biggest thing, is most parents are like, send their kids off to college, and they don't think through what's the consequences. At age 18, you lose legal rights to make decisions. So then that's why power of attorney and guardianship decisions are the biggest decision-making process. Is, do you need a power of attorney or guardianship? So guardianship provides, there's lots of different guardianship issues. So, what is a legal guardianship? So basically, if a person or adult is not able to communicate, or does not have what's considered a legal capacity to give direction, they need somebody to step in their shoes. And there's all kinds of different types of guardianships. There could be a guardianship, a full guardianship of the estate. There could be a full guardianship of the person. There could be a limited guardianship. A limited guardianship. So full means that you have full rights. You have the person does not have, so if it's financial, you have full rights to make all financial decisions when they have no say whatsoever. If you have guardianship over the person has no say in what medical decisions that they have. And you as the guardian can ask for advice from the child, but they really don't have much of a say. And knowing this, because this is important, because if you go to somebody that say, hey, I need a guardianship, you've got to be able to communicate, how much authority do you need? Because sometimes, and even with the guardianship of the person, you can't place them into a certain situation. For example, if I'll use an issue outside of the area, but you have a dementia patient. Okay, and the dementia patient wants to leave, and they want to go live back at their house. If you have a guardianship over them and you force place them, they can't leave. And based upon their diagnosis, that's an extra added layer to protect that person. So the guardian has that authority, but that's an additional issue. Limited guardianship is they need help and guidance, but they don't need full guardianship. But they also don't have the capacity to vocalize what their issues are. So if they can vocalize, they just get power of attorney. If they can't vocalize, they don't have capacity, but you want them to be able to drive, you want them to have the ability to do certain things. It's only a limited guardianship. So there's nuanced differences between the two.
Oh, the guardianship, do you have to go every year and reapply for it?
Once it's issued, but you will have to report. Most individuals, if you are on Social Security disability, your only focus is on on the health and welfare. You're not really worried about the estate. So you're not focused in on money and things of that sort. And if you have a pot of money that you're dealing with, you may have to report it on a regular basis. But if it's just the person, you're only reporting every 2 to 3 years, and you write there's a report, fill it out, and file it with the court. So it very streamlined once you're in the system, but getting into the system is really
Is it the same with power of attorney?
Power of attorney is like $150. Really quick. That's coming into my office, we sign paperwork and launch the car.
It doesn't expire?
It doesn't expire. Now they have the ability to revoke it. Okay. All right. We'll watch my time. Guardianships of the person in the state, I think those are pretty laid out what the rules are. And if you want these emailed to you, please don't hesitate. We can email. I know it is a little, I feel a little trombone myself,
You're old.
So they're a lot better than I know I'm old, but a lot better than when we had a discussion. Was it 6 or 4
Yes.
yesterday?
And I was like, but I'll email everything to you, so don't worry.
So, all right. So I think all that is pretty self-explanatory. Preparing a life plan. The key thing, being a special needs parent, is having a letter of intent. And this is a very, very simple document. And this is the thing that we are sending to everybody, right?
Yes, I just need to double check that I have everyone's email after, and I will send this to your email. So.
And this will be a fillable form. And with this form, this basically says who the person is and gives all the medical information that somebody will need to substitute for you. So what is meal times? What are the if there is triggers? What are the triggers? What are the different things that the person's going to need to be aware of? Who are the doctors? Who are the dentists? Do they have allergies? What kind of medication are they on? And what's the medication? Do they need assistance? What medical equipment are they going to need? And really lays out a very, very detailed need for that child. And this should be within any kind of a statement. This is like numero uno of a special needs parent. Having it prepared, having it established.
So would it be a really good idea to use that document as like taking everything in your head that you know that you provide for your child and dumping it out as if you were deceased?
Yes. Yes.
And then what do you do with that?
Print it out. If you have an estate plan, stick with the estate plan. If you have a folder specifically that you keep all your medical information, you want this to be one of the first things that people grab. When they're doing an estate plan, or they're looking at you because you're disabled, or you've got this, that, or that, whatever's going on with you. This prepares that next person of all the issues.
It could be revised often.
Yes, you can revise this as often as you need to. But having it printed, having it available, so that if you are gone, they know what's going on. Because nobody knows your child better than you do. So, they don't know. You give Johnny this item, and he's going to have an autistic reaction to it. We need to, or if this is a schedule, we become very scheduled and very oriented, and if things aren't in this category at this time, they're going to have trouble, and they're not going to know. They're not going to be able to ask you, well, what do you do in this situation? So you're describing those situations. So.
Also, too, like if your child is staying with their grandparent for the weekend, or like I babysat Todd's child before, and I kind of had all that information laid out for me, and it was helpful to me caring for his child, just because I'm like, oh, I don't know if this is going to happen, and then I had that right there for me to use. So it could be as simple as that, or it could be as complex as including it in your estate plan. So I just wanted to add that.
Yeah, definitely. She's my marketing person, but she is wonderful babysitter. But the problem is she's moving to Arkansas in June. So
it's too cold up here.
Oh, goodness.
I want to go back to the Guardian question. At what age should you start that process?
You should be thinking about it all the way up until the age of 18. But I would say,
I know it's too soon, but I mean, I know I'm itching up.
I would say 6 months before 17, or 6 months before 18.
So you're gonna be sooner than that, so.
Yeah. It doesn't take.
Way behind, so
Yeah.
thanks.
Because about 2 months in, or age 18, we're going to look at filing.
Well,
But we can't really file until the child turns age 18.
I wasn't sure how long the process took, is why I wasn't sure how soon it.
It just depends, it depends on the caseload of the attorney. So, 6 months is just you getting prepared, but judges are, police matters in St. Clair County, they're pretty easy to get into. You say, hey, it'll be probably about 30 to 60 days after they turn age 18 that guardianship is awarded, as long as there's no crazy factors like family members fighting or somebody arguing over, well, they should be.
Who gets to be the
Who
guardian?
gets to be the guardian?
Is it one person or is it both parents?
Well,
Just depends.
this is a common answer from an attorney. You never get a straight yes or no. It's always, it depends. Because again, it's very facts set. If the child's living in Illinois 90% of the time, and the other parent is in North Carolina, they're going to be, it'll be one parent that has primary decision making. But it just, yeah.
That's not the situation.
And, my husband did it. I'm here about the trust, I'm on the trust.
Yeah.
Me and my husband did it in St. Clair, we were both present, we're still married. I'm giving a specific.
Yeah.
And we both had to be there. And I had to explain to them that my son couldn't stay and wait there. I had to tell the judge, like, okay, he wasn't gonna be able, he's at school down the street, he can't stand here and wait. We were there for a while, because there was other things going on before. And so the judge was very kind and asked us a lot of questions, but we were both present.
When I took guardianship with my mom, like, I would say we were done within 30 to 60 days. It was super quick.
I was like 1 month after we turned 18 was when our court date was.
So what happens if something happens in that 30 days and the child can't make decisions on their own?
You would ask for temporary guardianship as well. Of course, we had to temporary guardianship immediately.
I think that's what I can do to my son this time on first of March. So, but at the same time, I'm just retired from the military, so my residency is in Texas, but I've been here for like well over 5 years. Just trying to figure out how to.
If you've lived here in the state of Illinois for more than 6 months, you're good.
Okay, that's the good part.
But one of the few positives.
Because you're still in between two states and you're still trying to figure it out. And at the same time, like he's also certification based, so he's gonna stay in school till he's 22. So that's already the plan.
Right.
The only thing is that now he's like 18, but you start seeing like those letters coming. I'm starting to see so many military. I've already served enough for both of us. So you're those things are really starting to come, and it's like, the bank account is saying, hey, he's 18 now. I'm like, no, so yeah, no.
But if you were to move, you can get guardianship here and move it.
Okay.
So you can move it from state to state. Once it's established, you just have to ask the court for permission to move.
Okay.
And then you can move.
That was my main concern. Like, what limitations did I have because I'm not a full-fledged representative of Illinois. I was trying to hold off without enjoying those 3 days. Man, stay just stay there long.
Do you have to have some sort of legal, like, my son took over my daughter. Do you have to have some legal documentation saying he can take care of her, part of attorney or whatever?
For
Just
short period of
basically
time?
the stuff that I do for her,
Short period of time or a long period of time or?
probably on Yeah.
These are the questions that you.
I know.
Write them down, because it's gonna be asked one day. And you want to be prepared.
Well, I'm prepared.
Oh, no, we're sneaking up. These are good questions.
All right, so let's talk about trust. There's, it could be, a lot of people call them special needs. And the key reason why I call it a supplemental needs trust is because the trust is there to supplement the needs of the child. And it is not there to provide for the full benefits of the child. The reason why we want it to be more supplemental, because we want to utilize as many of the government benefits as available. We want Social Security disability. We want them to pull from your pensions. We want them to pull from all the other resources that are available before your money starts kicking in. So, with the supplemental needs trust, it is really there to cover those expenses that they can't get on their own. They can't get the video games. They can't get they can't go to vacations. They can't do, maybe it's cable, maybe it's this, that, and the other. So it's there to supplement and provide an upgrade on their life.
I think it's nice without it being held against them. Like my mom wants to leave my daughter her house.
Mhm.
So, I mean, would it be left in my daughter's name or my name?
It would probably need to be based on your circumstances. It could be a supplemental needs trust that is the beneficiary of that house. And then the trust owns it and allows your daughter to live there. And in order to provide some benefits. We may need it to charge rent, provide for the upkeep and insurance and taxes and all that stuff.
We'll probably sell the house for money. It's probably what we end up doing with it. I mean, plan
Yeah,
to.
but if you put it in her name, you end up selling it, it's now a cash resource. So the key thing is, for that child, they can only have $2,000 in their name. So that is the maximum amount of money that most children can have. I call them children, even though they may be adults. But our children can only have $2,000 in their name. So we have to be looking at right now, do we have a savings account for first aid money? We have money saved up for this, that, and the other.
Basically, we need to get their savings account out of their names.
Or quit funding.
Because both my kids have both a savings account.
So that is that's going to be important.
Does that mean that part of the function of the trust would be to, for lack of a better way of putting this, replenish that $2,000 when needed?
So any excess above 2,000, and we'll get this in a second, but that may mean that you put that money into an ABLE account. An ABLE account is very similar to a special needs trust. There are, you'll hear first party trust, third party trust. First party trust could also be OMBRA, OMBRA trusts, B4A trusts. Those are all very similar instruments. Third party trusts, and then there's ABLE accounts. Those are kind of the three that we work with a lot. There's other different types of trusts, but those are the three main ones that we work with. If we're dealing with IRAs, let's see if I've got enough time to talk about IRAs. But if I look at those three, those are the three that we work on most importantly. So first party trust is assets that have gotten into their name. So they're over-resourced. They're, they've got $2,500 in their savings account, and we got to get rid of some of those resources. So we, and there's nothing we can really spend it upon that, unless it's just wasting the money. So we need to get it out of their name. So we usually use that first party trust as the mechanism to move money out. So that $500 would go into the first party trust. Get them down below that resource limit of 2,000, and now the first party trust. Same thing, but the ABLE account can also use that resource. So it's kind of a one either or situation. But with the first party trusts and ABLE accounts, you have to understand that all of the money that is sitting in those two accounts will, and if Medicaid pays $1, they can seize as many of the resources that they have paid. So if they have paid over $1 million in benefits over the course of your child's lifetime, then Medicaid will come back and seize anything that's in the first party trust and the ABLE. So that's the key with those two. And that's fine, and that's why planning is important, because we really don't want any of those assets available. And that's why we put it into a third-party trust. A third-party trust is really the key. And if they're going to inherit anything, it's going to be in the third-party trust. So.
And that won't be touched.
That won't be touched, and it won't be seized.
It won't mess them up to receiving.
Correct. Because it's not in their name, and they have no rights or access to that money.
So if it's not their name, then how do they access it if there's no rights to it?
They would have to go to a trustee. Okay. So that trustee would say, yes, we'll pay for this benefit or pay for that.
Can they deny stuff?
They could. So,
Be careful who you pick.
be careful who you pick. But they're also, they're not, even if you did a corporate trustee, they're not going to part about that. They're going to make, they have the kind of a fiduciary responsibility to that child and to take care of that child.
And we're paying that trustee to do this.
Yes, the trustee will most likely get paid to do this. Yes.
A very simple baseline question on trusts and trustees in particular. What type of person or persons are typically trustees of trusts? And I point that question this way. Is it somebody that you know who is familiar to you, or a family or a friend? Or is it an attorney's office or a CPA's office? Or?
So generally it's going to be, it most likely won't be an attorney or CPA. It will most likely be either a financial institution or somebody like Henry Jones people, or a bank. I think Commerce, right down the street, Commerce has one, UC Bank has one, First Mid of Illinois has them.
So that means then a corporation is a trustee.
Correct. Correct. Right. But friends and family can also be that trustee.
But then the decision making is up to a single individual's opinion.
Correct.
Whereas a corporation, the decisions of whether or not to grant what's requested is more based on policy and instructions to be provided for you.
Correct. And the important thing is, well, twofold. So an individual, I don't want to just tell you not to use an individual. because there are good financially responsible, and this is the key. This is who you're looking for in your trustee. Somebody that's fiscally responsible. You know, that they're fiscally responsible with their money. They should be able to handle your money and take care of your child.
Can they touch the money other than giving it to your child?
No. They may be able to charge a fee, but you gotta be careful with that.
So when they're paid, the trustee, does that money come from the
Comes
account?
from the trust.
Okay, it comes from the trust, so not someone else paying them, it
Right.
comes from the trust money, okay. What's like a typical amount, does it normally?
Corporate, it ranges. Some of them do a flat fee, some of them do a percentage. I think my trustee charged me $5,000 to get started, and then there's like a 1% or 1.5% admin fee every year.
Ours is 1%. Okay, so whatever's in the.
So if they grow it, you know, if they had everything invested in the stock market this past year and grew 30%, you know,
They're rich now.
Yes.
they're doing really well. You know, so it just fit, you're gonna have ups and downs, but that's generally the principle. So.
So basically, trust that in the stock market, or is that money you put in? I don't understand.
It could be, it depends on what you got coming in. So did you get life insurance? Did you have, assets? Do you have retirement accounts? What all do you have that you're managing, you are currently managing is what they're gonna be managing. Okay, so if you're in the stock market, then you're in the stock market. If you buy rental homes, you're in the real estate development and real estate investment. So, that whoever trustee has to be able to do all that. Okay. Any other questions on that? Yes.
You said they do the home, like, so if I want to leave my home to my child, they'll take the home, so to speak, and if I've got like 50 grand, and they just deal with all of that.
So if you put it in the child's name, child then says, I want to sell it, or somebody is forced to sell it, that asset now becomes an available asset.
Right, but will the trust, like, instead of leaving it to my child, even though I want my child to have a place to live, will the trust handle the home?
Yeah, they'll either make a decision that it's fiscally responsible for them to sell the house and provide rent assistance, or is it fiscally responsible for them to just hold the house, let them live there, and then figure out where to go from there. So, and that's a trustee decision. But if it's and that's the difference between a trust and other.
I want to piggyback something on her question.
Sure.
I'd like to clarify. I think I understand that if a home is in the trust, the trustee manages the ownership of the property. The child could reside in it, and essentially the trust is renting it to them, but there's really no net fee because its intent was to be the child's residence.
Sometimes you do charge it.
Yeah, it depends on how much you have in the trust.
Well,
So, or how you have it set up.
oh, okay.
So like,
And-
for us, we don't pay rent in ours, but there are some that do.
But like, Social Security will give you additional money for rent assistance.
Oh, right.
And then child.
And that money can go into the trust.
That money can go into the trust.
And I take it then that the trustee would probably take a portion of that as a fee, which is understandable, but the rest of it would actually enable that trust to grow.
There's gonna be costs.
Well,
You're gonna have insurance costs, you're gonna have some of those extra costs. So,
yeah.
so there's you know, it depends on how much money we're playing on. But, you know, there are definitely different things.
Are they trying to make the trust grow, or are they trying to just make it to where they get that, what they need to live on, and just, because eventually, once the child passes, then that money just goes back to the state, correct?
The third part of the trust or first measures? Sorry, first. So first, it doesn't matter. You know, you want this sort of grow, because then you've got more resources. But they don't have to, it's not like they have to go and put it all in growth stock mutual funds that blows. Because then it goes back to the state. But it just depends on the needs of the child.
So I do have to cut it off because Todd has to run.